Hello, commercial law students. This is a video lecture that will cover a very important aspect of commercial law in Article 3, and that is the nature of the real defenses, those few defenses that can be raised against a holder in due course. And it's important to understand those limited real defenses, and everything else is a personal defense, and a holder in due course will take free of it. Okay, so let's turn to the statute, UCC. It's 3305 where we find all this good stuff right there. It says here, except as otherwise provided, the right to enforce the obligation of a party to pay an instrument is subject to the following defenses. And now it lists a number of defenses. And the first one contains all of the real defenses. This is what you want to memorize. Let's go through them here. Infancy. And I think most, if not all, maybe bankruptcy will go to federal law, but most of these real defenses will rely on state law. That is, what is an infant? Is an infant 14, 16, 12? It may vary from state to state. And it will vary from state to state as to whether such a minor is relieved from contractual duties or under certain circumstances won't be relieved. It may be at the minor's choice. Okay, but you look at state law to determine, whether someone under a simple contract would be liable under the infancy laws. And same for the other ones, the other real defenses. You're going to look at state law. So infancy, duress is another one. Lack of legal capacity, that is, judged incompetent. Or illegality of the transaction, which under other law nullifies the obligation of the obligor. For all of this, infancy, duress, lack of legal capacity, illegality of a transaction, you all look to state law, and again, same is true with respect to fraud. But remember, it's not every fraud that we include as a real defense. Most frauds are not a real defense. They're fraud in the inducement. Like, I've got a Brooklyn Bridge to sell you. And then some poor rube pays for it and is now stuck with having lost the payment but doesn't have any title to the bridge because the person defrauded him. That's fraud in the inducement. Remember that fraud in factum, fraud in fact, that is the real defense. The only type of fraud that is a real defense. And that's when the person who signed the promissory note didn't even know it was a promissory note. And it's very rare that this will prevail in court because you have a duty to read. So typically, the classic examples are there's a farmer in the field who's illiterate, and someone runs up to him as insurance agent and says, hey, you need to sign your insurance policy. It's about to be up. But it wasn't an insurance policy, it was a promissory note, and the farmer was illiterate and totally defrauded as to the nature of the instrument. And that's what you want to look to, the nature of the instrument. That's where the fraud takes place, not the fact that you own a bridge in Brooklyn. Okay. But that fraud, you could still turn to state law to see how fraud is handled. So fraud that induced the obligor to sign the instrument with neither knowledge nor reasonable opportunity to learn of its character or essential terms. So that, in more words, says the same thing. And finally, discharge in insolvency proceedings. That is bankruptcy. Not any discharge. We've learned that there are other types of discharges. For example, if a endorser's liability is discharged after 30 days. That's one kind of discharge. That's a personal defense. Can't raise it against the holder in due course successfully. But discharge in bankruptcy by a court, that's different. If someone presents a promissory note that you signed the year before, you can raise as a defense to payment that I have been discharged from these obligations under bankruptcy, and then you won't have to pay. Okay, so those are the real defenses. There are other defenses, but these are the personal defenses. A defense of the obligor stated in another section of this article, or such as discharge, or a defense of the obligor that would be available if the person entitled to enforce the instrument were enforcing a right to payment under a simple contract. So what this gets to is all the other defenses that you and I are familiar with and exist under the common law, that could be raised as an objection or a defense to a simple contract for payment, such as breach of warranty, right? Lack of consideration, you never delivered what I paid for. Really anything else, anything that comes up under simple enforcement of a contract, any defense that might be raised, it's a personal defense. Only defenses that are effective against the holder in due course are the real defenses. And let's take one more quick look at them. We have infancy. We have duress, lack of legal capacity, illegality, fraud in factum, and discharge. Those are six real defenses. Learn them, and know that everything else is a personal defense. Okay, well I think let's leave off with that. Well, we'll take a quick look, because I know the first problem in this assignment has to do with this third paragraph, is a claim of recoupment. I'll read it through quickly. A claim in recoupment of the obligor against the original payee of the instrument, if the claim arose from the transaction that gave rise to the instrument. And remember the chapeau language up here, which is the right to enforce the obligation of a party to pay an instrument is subject to the following defenses. First defenses, and then it's subject to any claims in recoupment of the obligor against the original payee if the claim arose from the transaction that gave rise to the instrument. Okay, but the claim of the obligor may be asserted only to reduce the amount owing. All right, what is this about? Well, we'll look into it in the next problem, but what it means is this, is that someone who has an obligation to pay an instrument, such as a promissory note, can reduce the amount that they are liable for if they have a claim against the payee that arose from this sales transaction for which you paid with this promissory note. That's my paraphrase, but let's look at the problem, and I think it'll come clear. So I think this is where we are in the textbook, and we start with 126. I'm going to do 3 problems here, 26, 127, 128, and then look at 2 cases regarding the nature of that illegality, real defense. So let's look at problem 126. All right, this has to do with recoupment. As promised, Stephen Maturin bought a sailboat from Jack Aubrey, paying $500 down and signing a $1,000 promissory note for the balance due. Okay. So Jack is selling a boat to Steve, and Steve made a note, issued a note to Jack for $1,000. Maturin loved everything about the boat except its color, and he promptly repainted it his favorite color, black. Okay. Prior to the sale, I'm not sure the relevance of that yet. Let's keep going. Prior to the sale, Aubrey had told Maturin that the boat was constructed so it wouldn't sink, even in the roughest weather. This proved to be untrue when the sailboat went down in the first storm that came along. and it cost Maturin $300 to have it dredged from the bottom and restored. That's pretty cheap. Have a boat picked up and restored, but okay. In the meantime, Aubrey had given the promissory note to his father. I guess $1,500 is cheap for a boat, too. Anyway, in the meantime, Aubrey had given the promissory note to his father as a birthday gift. Aha! What does this sound like? Gave it to him as a birthday gift. Okay. Is this going to be a holder in due course? A father? Of course, he can't be because he didn't give any value. He was a donee. And so he's not a holder in due course with respect to the promissory note, at least not in his own right. Is he a holder? Let's assume so. I mean, it doesn't really say. It says he gave it to him. Let's assume that he endorsed it and gave it to him so that he is, in fact, a holder of, let's say, bearer paper. Is he a holder in due course? Well, of course, no, he's not. He's a holder. Of course, he wants the rights of a holder in due course. Can he get the rights under the shelter rule as a holder in due course? But only if his father or his son, Aubrey, was a holder in due course. Then, if you give it away, then the donee gets the rights of a holder in due course. But Jack Aubrey is not a holder in due course. He was a holder when he had the promissory note, but he wasn't a holder in due course. And why is that? Well, because he was the original payee. And the general rule is that an original payee is not going to be a holder in due course. Why is that? Because he knew, he was probably aware that this boat wasn't so great, that it wasn't as seaworthy as it claimed it to be. And therefore, he's aware of a potential defense, which in this case would have been a breach of an express warranty. And so, because of that knowledge, he's likely not a holder in due course if he has any knowledge of that. Yeah, so the father's not a holder in due course, or the son, Aubrey, Jack Aubrey, who sold the boat. He's not a holder in due course. He's just a holder as the original payee. And when he gives it to his dad becomes a holder. He also gains whatever rights his son had, Jack, but Jack's only a holder, so it doesn't help him. So at this point, there's no, unfortunately, the father has no holder in due course rights whatsoever. Okay, well, just a little analysis on the way here. Gave the note to the father as a birthday gift, and now the father presents it to Maturin for payment at maturity. May Maturin assert his damages against the father's demand for payment? And this is where you look at that third paragraph on recoupment. And it says, go back and look at it, that yes, you can recoup your losses against the amount that you owe, but only if it arises from the same transaction, and that's really the definition of recoupment. It arises, it's a claim for gaining back your losses, but related to the same transaction for which you have to pay on the transaction. And this is what happens here, that Jack Aubrey sells the boat to Maturin. Maturin issues the promissory note. Maturin then gets this shoddy boat, defective boat. He has to spend $300 to fix it. So he has this $300 claim. Really, these are the damages from the breach of an express warranty. That this vessel was seaworthy, and so he has a definite claim, and so he can take it and say, I'll only pay you $700 of that $1,000 because I am going to recoup the $300 that I've lost due to the result of the problem with this transaction, namely the boat, and that's perfectly legal. Now, of course, the father could take him to court, but the judge is going to agree with Mr. Maturin that he has a right to recoupment. Now let's look at a related but different, and you'll see it's legally significant. That is the concept of a set-off. A set-off is different from recoupment. It's also an attempt to recoup losses, to realize some kind of remedy for your losses. But in this case, a set-off is an attempt to recoup losses when the losses arise from a separate transaction from what you owe money on. Let's look back at the problem. So, I think we decided already that Maturin may assert his damages against the father's demand for payment under 3305, and a judge would agree. But now imagine a different situation where there's never a problem with the boat, but Jack Aubrey's dog bit Maturin on the leg 1 week after the delivery of the sailboat, and Maturin incurred $100 in medical bills as a consequence. Can the father now say, or can Maturin rather say that he's only going to pay what, $900 was not a $1,000 note, so he's only going to pay $900 now. Can he do that? No. You can only recoup, but you cannot set off losses. So that's the difference, because it's not from the same transaction. It has nothing to do with the quality of the sailboat. It's a dog bite. And so you can't recoup. Maturin is going to have to pay the full face value of the promissory note, $1,000. You can then, of course, go and sue them for damages from a dog bite under tort law. But you can't recoup. Okay, hope that's clear. Now let's dig into the true real defenses. I'm going to skip down a little bit. And take a look at a few problems here. All right, 127. When Ronald Rube, here we go, this is the Brooklyn Bridge example I've been sort of foreshadowing. When Ronald Rube, newly rich, moved to New York City, he was impressed by the Brooklyn Bridge when he first saw it. Simon Mustache, a con man, told Rube that he was the owner of the bridge, which was a lie, of course. And he offered to sell it to Rube for $2 million, described as a bargain. Rube paid $20,000 cash as a down payment and signed a promissory note, payable to the order of Mustache for the rest. Mustache negotiated the note to a finance company, which claimed to be a holder in due course. So you see how commercial law can be used for evil. This con man took a promissory note worth what, almost $2 million, and it looks perfectly fine, and he seems like a respectable gentleman, and he goes and sells it to a financier for a discount, I'm sure. But even if he sells it for $1 million, boy, he just got away with $1 million financial crime. And in a way, the UCC abets it, because it tells this financier that bought it, look, just look at the four corners of the instrument. If it looks okay, you're not aware of anything else, go ahead and buy it, and you'll be able to enforce it. And indeed, that financier will, as we'll see. Now, so you negotiated notes with a finance company which claimed to be a holder in due course, which let's assume they were. When Rube discovered that Mustache lacked title to the bridge, he refused to pay the note. Does he have a real defense of fraud here? And the answer is no. He does not have a real defense of fraud. It's no fraud in factum. He knew it was a promissory note. He was just duped as to the nature of the underlying transaction. And so that doesn't count. So he takes the loss. I mean, that finance company is going to be able to enforce that $1.98 million promissory note against him. They'll probably go bankrupt. Maybe he has the money, but they will be able to enforce it against him. And then he'll just have to try to find the con man, Mr. Mustache, and sue him for fraud. Separate case, just under the common law. But it's not the kind of fraud that will get him out of having to pay the instrument, which is Harsh, but it puts the burden on the person who's issuing a note to do some due diligence. He caused this problem. Who would buy a bridge for $2 million without a little due diligence? He deserves to be on the hook. Okay. 128, a child prodigy. Looks like we're getting into infancy defense here. So that was the fraud defense. Here's the infancy defense. Thomas Minor had been playing the piano since he was 3 and making professional tours of the world since he was 12. He looked much older than his 17 years. He signed a promissory note for $800 payable to the order of Mary Music Company as payment for a piano, planning to tour with it. Okay. The company was unaware of Minor's age. The payee endorsed the note, and the payee was the music company, right? Gave him signed a note, but they negotiated it over to Big Bank. Made some quick money for $725. So now Big Bank has the note, and they are a holder in due course, would appear. So when the first payment came due, Minor refused to pay. He told the bank to come and pick up the piano. He was disaffirming the sale. Who wins? It's a question of state law, but for our purposes, unless state law is unusual, he will be able to disavow the transaction. He'll be able to raise his infancy as a defense to payment. But it may differ according to state law. You might say that because he did this when he was 17, I think, and some state laws may make infancy 16, so it depends. But if he's an infant under state law, he can raise that as a real defense and not have to pay it whatsoever. So in that case, what is the remedy of the bank? They're an innocent party. They're a holder in due course. And nevertheless, usually because of that, we let them get paid. But now under these real defenses, no, you don't get paid. Sorry. Because we acknowledge holder in due course. You're pure of heart. You gave value. You did everything right. But the stronger policy impulse is to protect infants. So we're not going to make the infant pay. So what's the policy choice that the drafters make? Well, what is the remedy now? What can Big Bank National do to recoup its losses? Of course, they're going to sue the Mary Music Company. And they're going to sue them probably under endorser's liability. And so they'll get their money. They'll be holder in due course when they sue Mary Music Company. Mary Music Company could say, oh man, we didn't know. It's not our fault. But none of those are real defenses. And so they'll have to pay. Then Mary Music Company, they'll be the big losers. Now, Big National's happy. They got the full $800 now. Mary Music now is the loser. And they can't sue. They can try to sue the minor, Thomas Minor, under drawer's liability. But again, he'll raise infancy as a defense, and he'll win. So now Mary Music Company is the big loser. So that's good. So it works out to protect the holder in due course. Fortunately, there was someone else he could sue. If Mary Music Company were, say, bankrupt, then Big National would be holding the bag. But fortunately, they were able to sue. Now Mary Music Company is the big loser. And as it should be. Again, ask for a driver's license. Do a little due diligence, Mary Music Company, before you sell pianos and have children sign them. Okay, that was through 128. I think those are the two problems I wanted to do. Mental incapacity. It's pretty straightforward. That if you are judged incompetent, that certainly makes it easier. If you have been judged incompetent by a court, then you're not going to be forced. If you think if your great uncle thinks that he's Napoleon Bonaparte and he's signing checks all day on the French treasury, and then people find out there is no French treasury, and they come back and sue Napoleon, he's not going to have to pay. He's in an asylum. Okay, I think that's pretty straightforward. Let's take another quick look at 3305. Where to go? Let's see. Oh, there's my asteroid. Let's see, I think it's here. Yes. Okay, so we've looked at infancy. Duress, you understand what it means. I don't think we need to explain it. Someone putting a gun to your head. That would be under the common law. When are you under duress? And look at the case law for when that happens. Do you really have to be at the, does there have to be an imminent threat of death or injury? Someone going to chop off your finger. Threats to do things, it's going to depend on the common law. But you get the idea. It is, if you can prove duress, then you are excused from payment. As it should be. As it should be. Someone's forcing you to make a note, you shouldn't have to pay it. Lack of legal capacity, we just talked about. Fraud, we've spoken about. I think discharge in bankruptcy, insolvency proceedings is pretty clear. It could be under state or federal court, but you have to be discharged in bankruptcy proceedings. What haven't we looked at? The interesting real defense of illegality. Let's look at the phrase again. Illegality of the transaction, which, under other law, so there has to be some other law, probably a state law, at least in the cases we'll look at, illegality of the transaction, which under other law nullifies the obligation of the obligor. So if you can find another law, state or federal, which nullifies the obligation of the obligor due to the illegality of the transaction, then the maker, the person that's obligated, does not have to pay. All right? So this is illegal. What does it mean? Does this mean every illegal act? If there's anything illegal that touches a transaction, a payment transaction involving a negotiable instrument, will prevent the maker of the note or the drawer of the note, the drawer of the check, from having to pay if there's any illegality involved? Imagine this. Imagine there's a drug dealer, a kingpin. He has connections to South America. He brings in the coke and whatever else to Ohio. And he spends his money. He's, he's well heeled. And so he goes out and he writes promissory notes and buys cars, writes promissory notes and buys houses. Now, does the fact that his money is tainted from his illegal activity, is that sufficient? No. No, it's too distant. It has to be something related to the transaction. Okay, well, let's bring it a little closer to the transaction. Let's say this drug dealer, the importer, wholesaler, and then he sells his wares, his goods, to dealers, throughout the neighborhoods of Ohio. I'm sure I'm describing a real person. The question is, what if he sells these packages of cocaine to the local dealers and they give him promissory notes? They're sophisticated. These are not, just street dealers. These are people in suits, checking accounts. They write promissory notes. And so he sells kilos of cocaine to this dealer and this kingpin receives a promissory note. And now he wants to go back and enforce it against that local dealer when it becomes mature. Can that local dealer say, Your Honor, I don't have to pay that because it was part of a cocaine deal, and we all know that's illegal, and illegality of a transaction is a real defense, Your Honor, so bring the gavel down. No. No, that's not going to do it. And you could tell, that simply wouldn't be just for this drug dealer to get out of his obligation because he's dealing in illegal goods. I mean, it's simply not fair. Of course, he should be made to pay. Just like, the IRS. They don't care where you make your money, as long as you pay them. And that's what gets a lot of criminals in trouble, as you know, from Al Capone and on, is just the fact that the gain and the money that you're gaining flows from illegal activity. IRS doesn't mind. They just want their share. And a court in this case wouldn't mind. They're going to impose liability. They're not going to weaken the UCC and the enforcement of a negotiable instrument merely because this guy was involved in illegal activity. It's just equities don't ask for it. Okay, so those are a couple of thoughts just to kind of prime the pump here, and let's look at the cases we have and find out what does it take to avail yourself successfully of the illegality defense. And we'll look at two of them. Sea Air Support, which is actually a collection agency. Here, Ralph Herman wrote a check for $10,000 payable to Ormsby House, a hotel casino. So Ralph has been gambling. And he wrote a check to pay, and exchanged it for 3 counter checks he'd written earlier. So he'd written 3 checks to the casino to get chips, and then at the end of the day, he just wrote a $10,000 check. He took those 3 checks back and wrote a $10,000 check to cover all of them. And anyway, Ormsby House had his check, and they weren't able to get it. It bounced due to insufficient funds. Right there, insufficient funds. NSF. They might stamp it. NSF. Insufficient funds. So what do? Of course, they're going to sue. They're going to sue Herman under drawer's liability, and Herman raises the defense of illegality. And the argument that Herman raised is that there was a law in the books called the Statute of Anne. Statute of Anne. I think this is some kind of a misprint. Statute of Anne. And the Statute of Anne said that statute provides that all notes drawn for the purpose of reimbursing or repaying any money knowingly lent or advanced for gaming are utterly void, frustrate, and of none effect. Now it says notes, but here we have a check, but apparently it encompasses checks as well, at least according to the court. And the court affirmed the holding of the trial court, which dismissed it because of the Statute of Anne. And the court here affirms that holding, that this is a proper application of the illegality real defense. In order for the illegality real defense to be successfully raised, there has to be a black letter statute on the books that not only makes it doesn't make the behavior the transaction illegal, but it makes any instruments issued in connection with a certain transaction, it makes them void. It has to really clearly state that this statute is going to void any instruments that are issued in connection with, here it was gaming. Elsewhere it could be drug dealing. Elsewhere it could be racketeering, I don't know, terrorism. Here we found, Herman was lucky, he found a law. It's very surprising that it was there in Nevada, Las Vegas, and this was like 1984 in the 80s, relatively recently, and the casinos have been booming for many, many years, for decades. Nevertheless, there was this law in the books making notes void if they are used in connection with gambling. So here, Herman wins. He doesn't have to pay. It's not quite fair, but hey, that was the choice the state made, that there are some illegal some activities where they don't want promissory notes to be used, to be enforceable. Okay, so that's the this is the cornerstone case for the illegality defense. Think statute of Anne, black letter law, voiding an instrument. That's what you need to look for. And so you see these real defenses narrow, right? The fraud defense is narrow. Illegality is narrow, which is also what we want. We don't want, big barn door defenses to a holder in due course. We want them to be able to enforce their instrument easily. There's one more case just to drive this home, and that is the Kedzie case, which has to do with someone not being a licensed plumber. And that's the illegality here, and they're trying to raise that as in the context of an illegality real defense. And in this case, well, we'll see what happens. Let's see the background. Pursuant to a written work order, Fred Fentress agreed to install a flood control system at the home of Eric and Beulah Hodge, the Hodges of Chicago, for $900. In partial payment for the work, Mrs. Hodge drafted a personal check payable to Fred Fentress, AOK Plumbing, for $500 from their account at City Court. The system's components were not delivered to the Hodges' home, and when Fentress failed to appear on the date set for installation, Hodge telephoned him to announce the contract canceled. Hodge also told Fentress that he would order Citicorp Savings not to pay the check. Nevertheless, Fentress presented the check. Let's see what happened. Nevertheless, they presented the check. When Currency Exchange later they presented the check at this Currency Exchange first. They didn't go to the Draw-You Bank, Citicorp, but they went ahead and cashed it. And they endorsed it, so it has endorser's liability, this crook, Fred. He cashed it, endorsed it, he got his money, ran off, I'm sure. But then Currency Exchange, the check cashing agency, they want to present it, and they're a holder in due course, and they present it at Citicorp Savings, and of course it wasn't paid because there was a stop payment order placed on it by the Hodges, and Citicorp needed to follow their instructions. They properly refused to pay it. All right. The Currency Exchange, alleging it was a holder in due course, then sued Beulah Hodge as the drawer of the check. They refused to pay it. They dishonored it. And so now they can sue the drawer. And here we go. The Hodges assert a defense under 3305, the UCC, back in the 80s. Hasn't changed. Under that section, the claim of a holder in due course of a negotiable instrument may be barred based on illegality of the transaction. And then the court goes on to explain what illegality of the transaction requires. And there's distinction that's made here. Some jurisdictions find reason to draw a distinction between the voidness of a negotiable instrument and the underlying contract or transaction. And that is the majority rule. That you need a black letter law that says that the instruments negotiated in connection with such and such type of transaction are void. And this court is convinced that it's the better rule, and so it follows that rule. The defense here was by Fred. Apparently, I'm sorry. Let's see. We were talking about the the defense. So the attempted real defense that is being raised by the drawer of this check, which is the Hodges, was that it was illegal, that there was a licensed plumber, that unlicensed plumber. This guy was a scam artist. Could they use fraud, that he defrauded them, promised them to install it, but then never did? No, that's fraud in the inducement. That's like selling someone the Brooklyn Bridge that you don't know. So they can't use that real defense. They got to come up with some real defense. Otherwise, that holder in due course, that check cashing agency, is going to successfully enforce this check against the drawer under drawer's liability. They need a real defense. Fraud isn't going to work. They try illegality. And what is the illegality? that he's an unlicensed plumber. And the court agrees that it is illegal to practice plumbing without a license, but that doesn't rise to the level of supporting a real defense of illegality claim. They need to find a black letter law that says any instruments issued in connection with services provided by an unlicensed plumber are void. That's what you need. Those are rare, narrow defense. And the Hodges lost this case. And it's too bad because they're victims, right? They're good people. Why should they have to pay? Well, I think that this check cashing agency was maybe even more innocent. Okay, the check looked fine, and maybe they checked his ID. It was Fred Fentress. It was his signature. I mean, they don't have any understanding of the underlying transaction, and they really have no way to investigate it. All they have is this check. They don't know what's going on at all. They're an innocent party. So should they get paid? Should the check cashing agency get paid and win? Or should the Hodges not be forced to pay and let them win and leave the check cashing agency holding the bag? Which is proper? And the way that the drafters decided it is that it's better to make the Hodges lose and to let the check cashing agency win, because they are an innocent holder in due course, pure of heart, and we don't want to weaken their confidence or the world's confidence in promissory notes or checks. Okay? The Hodges, they're losers. You know, I sympathize with them, but it's most just that they bear the burden because they were in the best position to avoid this mess in the first place. You don't hire unlicensed plumbers. You ask for their license. You seek recommendations. You look at their reviews on Yelp. They didn't do their due diligence, and so they deserve to pay the price. Now, of course, they can try to find Fred Fentress and sue him for failure under breach of contract. They had a contract for him to replace this flood machine, and since he didn't, he should regurgitate all the money that he was paid. But of course, it's going to be hard to find the con man, this crook. That's the way it will play out. So that is the end of our discussion of real defenses. Hopefully they're all perfectly clear to you now. Let me know if you have any questions. There was one last question that I did want to get to, and it involves a separate issue, and that is the forgery of a maker's signature, or the forgery of a drawer's signature. We've discussed forgery of an endorser's signature, and that no one can be a holder once an endorsement is forged. That's the legal effect of forgery of an endorsement. But the forgery of the maker's signature in the process of issuing the promissory note, or the drawer's signature in issuing a check, what are the legal effects if that is forged? That's what this last problem gets to. I believe it's problem 132. Yes, it is. Is it here? What happened? I feel like we may have skipped over it. We're going to find it though. Maybe we didn't. Aha. Okay, let's jump right into problem 132. Jimmy Slick, an expert con man, went into John's Jewelers and told John, the owner, that he was Milton Money, the richest man in town. John was too awed to ask for identification. Mr. Slick then picked out several very expensive pieces of jewelry and signed Money's name to a promissory note to pay for them. Slick skipped town with the jewelry. So now this jewelry store has this promissory note with the forged signature of the maker. It's not Milton Money that signed that. They hold on to it. They still don't know that. And when the note matured, the 10th National Bank, a holder in due course to whom John had negotiated the paper. Okay, so he had negotiated it to a bank. That's fine. So now the bank holds on to it and waits for maturity. And when it matures, the bank takes it to Milton Money, the richest man in town, and says, hey, we would like you to pay this promissory note. May Money refused to pay a holder in due course. This is interesting. What do we do? Holder in due course. I mean, we just finished the section on real defenses and the fact that a holder in due course is not going to be subject to real defenses. Before I think it's good to look at one provision here. B. Now we've learned about all the real defenses. B is the operative provision in 3305 saying that the holder in due course is immune to all defenses except for the real defenses. And this is where it says it in 3305B, the right of a holder in due course to enforce the obligation of a party to pay is subject to defenses of the obligor stated in subsection A1. And those are all the real defenses in A1. You're subject to those defenses if you're suing someone to pay an instrument. But a holder in due course is not subject to defenses of the obligor stated in subsection A2 or claims in recoupment stated in subsection A3 against a person other than the holder. So there you go. You get the holder in due course is only subject to the real defenses in A1 and is not subject to anything else. The personal defenses and claims and recoupment. Okay. So I wanted you to take a look at that, but let's get back to where we were. Was that we had just finished talking about all of the real defenses and that only real defenses can be successfully raised against a holder in due course. And I'm sorry, but as has happened before in this course, there's a wrinkle. There's a little nuance that I want to add to this list of real defenses. And that is a forgery of the maker or of the drawer. Milton Money, in this case, his signature was forged as the maker of this note. He does not have to pay it. It's not one of the real defenses. On what ground does he not have to pay it? Under the fundamental concept in 3401 that a party is only liable on an instrument if that party signs the instrument. Milton Money did not sign this instrument. All those real defenses are real defenses that you can bring against someone who signed the instrument and is liable on it. But this is a preliminary question. Really, Milton Money is not even liable on it. So there's no need for him to even raise a real defense to this demand that he pay the promissory note. He doesn't have to go there because there's no liability whatsoever. And that's in 341. Let's take a look at it. A person is not liable on an instrument unless the person signed the instrument. Period. Okay, pretty cut and dry. So, what do we, yeah, there's nothing else left here. So how would I, if I were you, how would I treat or categorize this defense that Milton Money is raising, which is a defense still. It's a defense that I'm not liable because I didn't sign it at all. You know, it's not one of the real defenses that are enumerated in 3305A1. So don't put it under, in the in the list of defenses, of real defenses, but maybe added on, appended as another defense, even though it's not a real defense, it's another defense that can be raised by a party that's being sued to pay on an instrument. And you can raise this even against a holder in due course, which is what the bank was here. They went to Milton Money. Even a holder in due course, which will always get paid unless you can raise one of the real defenses. You'll always have to pay the holder in due course. But this is one more defense that could be raised. If you're being sued and you don't have a real defense to raise, this is the way to go. Hey, I never signed that. So this is the kind of defense you're going to see if someone steals your checkbook and starts writing checks all over town. And then, of course, you find out that your checkbook has been stolen, and you put a stop order on all those checks. And so your bank properly dishonors them when they are presented. But then the holders, who are holders in due course, let's say, come to you as drawer and want to force you to pay at a drawer's liability. Well, you can't say you're an infant, or there's duress, or illegality, or fraud, or bankruptcy. But you never signed the instrument. That's the defense you raise, and that will defeat even a holder in due course. So, I think I've made that more than clear, I hope. And that's the end of this lesson. And we'll see you in the next module.